Looks like Jose just got in here.
Hey guys, sorry about that.
No, you're fine. It was
Chilling
funny
here.
when Sam joined in, your name popped up. So I'm like, "Hey, Jose," and then she turned on her camera. I'm like, "Wait a second."
Wow, I got really pretty. I didn't even know I could get my hair that long like that. If I did my hair like that, it'd pop out like a fro, right? So
That'd be a good look for you, Jose.
Mine does the same thing.
yeah.
There's lots of straightening that happens. It's either, yeah.
Especially at the Corioto gym.
Oh yeah. Oh
I'm sure the
yeah.
kids will love that.
Oh, they think it's hilarious when my hair grows out. You could try to make fun of me. Try it being the operative word there, but yeah. So thanks for coming, Sam.
Happy to be here.
You guys
So
want to go ahead and jump
yeah,
into it?
let's punch it.
Awesome. Let me, like I said, I just put a small PowerPoint together. Let me share it over and we'll get going. Give me just a second.
Probably mostly just got contact information and the
Yeah,
normal disclaimers.
yeah, all that good stuff. Let me know when you guys can see it.
Yep.
Yep.
Sweet. Cool. So, hello everyone. Welcome to today's webinar. And today's topic is going to be navigating the pros and cons of mergers and acquisitions in healthcare. My name is Ray Walters. I'm joined by my co-host, Mr. Jose Delgado Jr. If those of you are attending for the first time, me and Jose have been conducting these webinars since October of 2023. So if you guys are interested in catching up, I will put our YouTube channel in the chat. We've done quite a few videos since then. But anyways, we're excited to have you all today. Also, we're thrilled to have a distinguished guest speaker today, Miss Samantha Prokop. She's going to be sharing her extensive knowledge and experience in this field. Samantha holds a JD from the University of Akron School of Law. She currently is the head of the healthcare transactions team at Gunster Law, which is a Florida-based firm where she advises corporate and healthcare companies on establishing new businesses, mergers, acquisitions, and business disputes. Samantha, glad to have you here.
Thanks for having me.
Yeah. So let's jump right into it. Normally we have our audience is office managers and small business practitioners, a few colleges here and there, but mostly in the small setting. And I'm sure you're seeing this more than I am, even that there are larger organizations that come in and offer the moon and the stars to these practices to join their ACO or join their MSO or join their private equity group. You know, pick a couple of letters and they just come up with a new one every 6 months, I swear. What would you say is like 50,000 feet viewpoint? What's the first thing I want to look at when I'm getting this kind of opportunity presented to me?
Yeah. So from the sales side, couple things that we look at is the first thing I'll ask a client is where are you in your career, right? Is this, I want money, I need investment, I need a cash infusion, I want to get out of managing this thing, it's too stressful for me. Or are you maybe older, looking to retire and want to make sure that you get something out of your practice versus shutting it down? I have a lot of smaller practices that face that as well. So the first thing I say is really, what are your goals? And then from there, then who's a good fit for you as a potential buyer? Is it private equity? Is it a model where physicians still control? What does your culture look like? If you've created a culture and your keeping your employees employed is important to you. We'll look at that. Jose, to your point, our buyers can come in several different forms, right? They could be other physician practices. They could be independent physician associations. They could be insurance companies, be private equity groups. It just really depends. I think for my clients is what are your goals and who's going to be the best fit for you for what you want to do.
So I imagine that part of the reason why this is popping up is, one, money's been cheap for a while. And then two, there's a crop, I would say quite a significant crop of independent physicians that started their practices 30 years ago, 35 years ago. And so I think that they're tired of the giant upheavals in the industry, right? Because maybe they got started and graduated med school right at the advent of the HMO nonsense in the late 80s, early 90s with major medical and the HMO nonsense. And then they graduated with the PPOs, and now they may not be Medicare patients yet, but they're done, So I feel like part of it is they want to sell so that way they can extricate the responsibility, is what I feel like. They don't want to stop practicing medicine. They love it, but maybe they want to stop all the other stuff that they don't like to do.
Yeah, I think you're right on. A lot of the driving forces for my clients tend to be either complete burnout, right? I'm
Yep.
just done managing. I don't want to be the marketer and the biller and the coding expert and the quality analyst and and see patients and have to be at the HR department and
Yep.
have to order supplies. Like it just becomes, burnout. I want more time with my family. The other bigger driving force, I think, too, is it's harder and harder for smaller physician practices to get favorable rates with insurance companies. We've seen a lot of consolidation. We now have 4 major payers right now, and they're even talking, right? And they're even in talks still on further consolidation. And so, I've got providers that call me all the time and say, I'm getting paid 50% of Medicare. I can't do this as a dermatologist. I can't, this is crazy for me. They can't afford to stay with the insurance plans, and they need to leverage somehow. So that may be cash infusion, that may be consolidation, getting to bigger size and scale, more patients, so they can go to these payers and negotiate better rates. It may be joining an IPA, but I think a lot of times it's network status with these insurance carriers and rates that is a huge driving force in consolidation.
So when you mentioned IPAs, I haven't seen too many IPAs popping out over here in Northeast Florida. Are they kind of setting themselves kind of like the ACOs? Because I know ACO version 1, you had to have a hospital attached to you.
Mm-hmm.
ACO version 2 pretty much hosed all specialists and only wanted certain types of primaries. And then now I think there's even a newer version that they're trying to become max with Medicare, so then they can get the lives attributed to them and go full risk, similar to how some of these Medicare Advantage franchisees, for lack of a better term, are operating. If I'm a small practice, is there a default model that I would say absolutely hell no to? In my opinion, ACO version 1 was a garbage idea from the jump street. It should never have passed go. But some of these do seem viable if I have the right patient population, right?
Yeah, and I think that depends on where you are as far as what's your specialty. Are you primary care or your specialty, right? Are they going to accept you again into those networks or ACO participation programs, right? Primary care, your participation is a little different than specialists. With the IPAs, what we're seeing, yes, they are out there. Do I see them popping up all over the place? No, I see them more specialty based, and they're more geared towards commercial versus Medicare. So this would allow you, the IPAs, for instance, I see surgery IPAs, dermatology IPAs. They allow smaller practices to come together. The IPA often takes on risk contracts, but let's say on the commercial side, right? And then says, okay, surgeons, you're going to cover for a per member per month fee all of these patient services. Now, the participating providers oftentimes get paid fee for service by the IPA, right? Which then is the one who adjudicates claims and pays the providers.
Am I the only one that froze? Or
so you're fine. Jose, I don't know if you can hear me.
Jose,
You're
I
fine.
hear you. Okay, I hear Sam.
yeah, okay, all right. I froze for a hot second. Sorry about that, Sam.
No. So I mean, I really think it just depends on IPAs. Could be as far as, would you say no to any certain model? It really depends. We have to look at your practice, who's your patient base, and what makes financial sense for you, right? Like, what are your pain points, and does this solve it? A lot of times for my smaller practices, accepting risk is not the way to go, but signing up to participate with like an IPA where they're not necessarily accepting risk, but they're a participating provider getting paid, and now the IPA is their payer source. and they get more favorable rates because the IPA gets better rates and they're, specialty driven, a lot of times that makes sense. So it's really going, and I always say, you've got to follow the money, right? You've
Yeah.
got to be willing to look at where are we losing money and drop it if necessary, and what can, what can get us where we need to go financially.
That model of IPA kind of reminds me how about 15 years ago, maybe when we first met, there was always a bunch of specialists getting together to start a new surgery center. And it just seems like a natural progression off of, well, we already have the surgery center. Might as well just evolve that out a little bit further. Does that sound about right?
Well, what we find is the IPAs are managed a lot of times by physicians, where the ACOs aren't necessarily, right. ACOs
never. They're never managed. ACOs are never managed by physicians.
Yeah. So it's a different model where the physicians are managing. And what I found, like, for instance, let's say the surgery IPAs, the goal really is, if the IPA is taking a per member per month fee and it's got contracts, let's say with Florida Blue, for example.
Yep.
How does it make money? Penny saved is a penny earned in a risk model, right?
Yep.
So if I can get patients out of the hospital setting for their knee replacement and into an ASC setting or an office-based surgery center setting for a certain procedure, it's going to save on costs. Physicians that are employed by hospitals are incentivized differently, right? They get paid, and they can be paid productivity or RWRBUs. They're incentivized to send their patients to that hospital, which tends to be the highest cost possible. The IPA model lets the physicians stay in control, and then it lets them control the setting. So yes, to your point on the joint ventures and the ASCs, are physicians encouraged to send them to their own offices and their own ASCs? Absolutely. But in the long run, it's also saving money for the IPA.
So do you find on some of these situations where, because even with the conversation that you and I had yesterday, and I have conversations with people all the time, we have to worry about Stark. But then everything coming from the federal government tells me that Stark matters, but doesn't really matter because they want you to kind of violate Stark to control costs. So it's like, I sit here and I'm like, okay, so which one do I end up being on the gray? Like, I'm gonna end up in a gray area. How do I deal with that Stark issue?
So Stark still applies no matter what. We have seen in the past couple years Stark laws be revised to add additional exceptions, right? So we saw new exceptions for like value-based purchasing arrangements and certain risk models. So I think the government's trying to expand some of that. I know the ASC for Stark, a lot of things done in an ASC aren't subject to Stark, but they're subject to kickback, anti-kickback statute considerations. Those are all still very important to consider when you do these deals. You can get tied up very, very quickly. IPAs, for instance, that do business with hospitals. We've been having issues recently. That's become kind of a trend where, okay, our physicians that participated in the IPA have been acquired by a hospital. Now I'm doing business with a hospital. Well, guess what? Hospital inpatient, outpatient services are all subject to Stark DHS. So when I have that financial relationship, we've got to analyze that. So it hasn't gone away. And I think that's kind of a misconception in some respects, even when the ACO models came out. My physicians were like, you don't have to deal with Stark, there's a waiver. I'm like, there's a waiver, but there's certain limitations. It's not just go do what you want to do. So I think we see the government kind of expanding that. It's taken them some time, but Stark being a strict liability statute is something you still cannot mess with, and you have to analyze very carefully in these arrangements.
Sam, is there any state specific regulatory challenges, like especially here in Florida, that you have to navigate through at all?
Yeah. So whenever we're setting up any of these arrangements, right, like we're talking revenue enhancement right now, but if we're specific to like M&A, right, we're looking at change of control provisions. If I have private equity, if I go from physician owned to non-physician owned, do I need some type of healthcare clinic license? Are we changing the operations that we need to expand the licenses? Florida is one of those states that has laws like healthcare clinic license does not show up in most other states. It's a very nuanced Florida issue. It's very complex. Who can own, can I have a multi-specialty practice owned by a chiropractor? There's just all these kind of Florida nuanced issues. The other thing we look at is antitrust issues when we're doing these consolidations. Have we gotten too big? Are we violating any antitrust issues? And at a state level, Ray, to your point, states also have very specific antitrust issues we have to look at as well.
Oh, good to know.
Okay. So I'm a small practice. We're looking at the tail end of meaningful use ACO version 2.0, version 1.5. I joined an ACO and I forgot about it. Now we're COVID now happens and chaos with COVID, and I say, screw it, I'm done. I want to sell. But I know a lot of these private equities have their own deals and they want those Medicare lives attributed to them, not to some other ACO. Do you find that saying yes to a couple of deals down the road and not revisiting any of these what does it just flat out kill deals, or do you see that, all right, well, we gotta just step, and this is not gonna be, we bought the house tomorrow, we're gonna have to set this up for 6 months from now because we've got to untangle so we can retangle?
It's a very good question. So in my M&A deals, there are two things, well, maybe three, that hold things up. One is surprise compliance issues.
Yep.
The second, usually in the billing context. The second is landlord consents. There's always usually a landlord consent when you change an owner. I want a new guarantor, right? And I swear that always people wait till the last minute to identify that. And like, guess what? If we don't have the building and we can't see patients, that's a huge problem. And then the third one, to your point, is vendor and payer contracts. We have to look at all of those. And depending if we're doing a stock or asset deal, do we need those contracts? That usually drives how we structure, whether it's a stock or asset deal. But also, even in light of that, if I purchase the company versus just the assets, my Florida Blue contract may have a clause in it or that says you need anytime there's a change of control, then you have to notify and get consent from Florida Blue or the contract doesn't transfer. And so we have to look at those type of contract provisions and make sure that they're not going to tie anything up. I have had ACO issues come up, but you're not stuck in an ACO forever. So as long as we look, usually that's in the primary care realm, we run into that, right? Where the patient lives are attributed. OB can sometimes get into that as well.
Yeah.
If they're considered primary care. So that's where we typically see that. We have to evaluate what there's all kinds of ACOs. What's the program look like? What's the contract look like? And then a lot of times we just have to say, okay, we can't switch the patients until this time. Or, we end up having to sometimes we get creative and create new entities and assign patients somewhere else. So it just kind of depends. So that has been it's something we consider and deal with, but hasn't tied up deals to a great extent.
Gotcha. So what would you say is the hardest piece? Because I know that for you, the compliance surprise that happens always 30 days or 2 weeks before closing is the one that pops up for you. That is the most difficult for you. But what normally is the hardest thing for buyer and the seller to react to when they're trying to get this deal done? Is it like one of the partners magically doesn't want to sell, or is it like the billing side of things is really complex, or is it, hey, is this a one person owns the location and doesn't want to sell the location, but the location is extremely important, so then you have to change it into a rental deal rather than, you know what I mean? Like, what would you say is like the hardest hurdle for buyer seller to deal with?
It's really last minute surprise issues, and a lot of times those are in the billing context. So we try a lot of times, with my clients, I would love to have them. I'm like, do not tell me when you've already signed a letter of intent. Do not engage your attorney at that point. Like, you need to engage your attorney or even a healthcare consultant 2 years prior to deciding to sell your business. Why? Because as a seller, a lot of my seller clients don't realize you have to get your books and records in order. You've done transfers to family members or employees and this and that, and things aren't in order and your documents aren't up to date. Your stock certificates aren't current. Dr. Bob lost his stock certificate. And so now we got to issue these at the last minute. And so a lot of those last minute issues, if we can get involved ahead of time, we can prepare them. We can say, listen, a buyer is going to want to look at every piece of paper you have. It's going to be stressful. You're trying to run your practice. So I like to get them ahead of time and say, I have a list. I know what they're going to ask for. Let's get the stuff. Let's organize it. Let's get a consultant involved. Let's get evaluation, just like you would if you're going to sell your house. You don't just pick a number out of thin air. What is
Yep.
this worth? What can you likely list it for? Let's make sure your books and records are updated. Let's make sure your financial statements are in order. There are things and strategies we can employ now where, gosh, if we enter into this contract and you get this going for another 12 months, that's going to change your EBITDA multiple on a sale, 4 times. If we had an MSO, I can double, triple, quadruple the, value of this practice. There are things that we can do a couple years ahead of time to implement to increase the value and make it a better sale. So I think that's probably one issue. The other is really surprise billing issues. So first thing I do is tell clients, get a valuation. Second thing I do is get a sample claims review. Have an outside company, not your current billing company, do a small claims review. It is not that expensive. We can usually identify systemic errors. But I can tell you, I've had 3 deals that have come to a halt or not gone through recently just because of nurse practitioner incident to billing issues. Billing nurse practitioners under physician numbers, when the services don't qualify as incident to, when the physician is not on site, they don't understand it's Medicare. Now we've identified it. The other side has identified it in their claims review because client did not want to do their own claims review ahead of time. And now what you've done is A, created a whistleblower from the potential buyer who now knows the issue. B, we have a duty now to report and refund to Medicare. And our 60-day clock, right, starts ticking and there's timeline and we have no choice. And the buyer is going to potentially use that to reduce the purchase price. And so it really becomes, and then all of a sudden my sellers, well, I don't want to sell and I'm not doing this. I'm like, well, now we know about it. Now we have to deal with it. And your purchase price just went down. And so if we can avoid those types of issues ahead of time, that's really what we're trying to do.
It's funny you say 2 years. I usually tell clients 3 years just because I tell them it's just like if you're going to buy a house. The bank is going to want to see 3 years of everything dating back, in your entire genealogy to your great grandparents and forwards to your great grandkids. So if there's not everything buttoned up, assume that the deal isn't going to go through, especially for the number. And the number always goes down. It never goes up. So guys, if you're planning on a sale and any hiccup pops up, just know every single time that a hiccup happens, it means less money in your pocket.
Yep.
I've never, let me see. And I don't think I think I can say with pretty high confidence, we as a consulting firm have never seen a deal where the dollar amount goes up when there's a hiccup. It goes down. Even if it's stupid because even if there's a positive thing that we find through the hiccup, it's the fact that everything wasn't ready.
Right.
Or the fact that, hey, well, that's nice, but you agreed to that number back there, so it's really interesting how that stuff works out. I know that you're not an accountant, but I always like to have the question, right? For me, it's the lottery ticket question. Do you take the lump sum? Do you try to take it over a couple of years so you avoid a few tax implications? Sometimes it doesn't matter.
Invest it back into real estate or something.
Yeah. Well, sometimes it doesn't matter too, because it's like, well, crap, I'm going to stay on as a provider and then I'm going to get a portion of the sale. So I'm going to get hosed at the highest rate no matter what at that point. So what do you normally have a recommendation for that, or do you tell them go talk to the accountant?
Yeah, well, we definitely, so the first thing we do is we get their tax advisor involved. Even if we have our tax attorneys involved, we don't know your history, your financials, how things have been reported, right? We didn't set it up. We don't know necessarily the tax elections that have been made. So we always want to talk to the accountant. We don't know what other investments this physician seller might have. So what we do is we will typically get one of our tax attorneys involved. We talk to the client CPA or tax advisor. And then sometimes if we, again, get enough in advance notice, we can restructure some of this too. So it can be held in trust or things can transfer and there can be added tax benefits for that. And some type of private wealth estate planning strategies can be employed. If I know a client's going to get a lump sum, there are things that our tax attorneys and private wealth attorneys can do pre-sale to help
Yep.
make that more advantageous. I don't have a chance to do that when you call and the LOI has been signed and right, we're ready to close this deal.
We're 2 weeks from closing,
Yeah,
and
like there's not
this has
enough
got to
time.
happen.
late.
My wife already set up the
Yeah.
Europe trip for 3 weeks from now, and
Yeah, the big question for our clients really becomes a lot of these deals, especially if they're private equity, most buyers are not just giving lump sum payments unless it's a physician to physician deal. They want some type of skin in the game for the physician and incentive to keep the business going. And so outside of
Absolutely.
a pure retirement, usually I tell my physicians, look, you're probably going to get a deal that involves some cash. If it's a private equity deal, there may be some rollover to a bigger entity where you can cash out if there's a sale. Or a lot of times that's not even on the table. It's like partial cash, but there's a deferred purchase price and there's an earnout, which is also when we talk about Stark, right? They're subject to Stark and anti-kickback.
That's some funny commission structure right there.
Yes, we have to be very careful, but a lot
Does
of
not
times,
sound smooth at all. Just the whole process. It
Oh
sounds
gosh,
stressful.
yeah.
yeah, but a lot of times our clients are surprised, like, well, what do you mean I'm not getting this all up front? What do you mean I have to work 3 to 5 more years? And by the way, the buyer is going to be in complete control of your business. So now your purchase price is dependent on a certain level of productivity of this business over which you have no control now. And so those are the things
Yes.
on the buy side and the sell side, you know, depending on what side we're on. If I represent seller, we're trying to get that stuff out of there. We're trying to make it reasonable. And there's a lot of regulatory issues with some of the way, you know, these earnouts are presented. So you have to be really careful.
Trying to think of some other stuff that normally I see and it destroys the whole deal. I find that sometimes, because it's healthcare and healthcare has so many components, and if you've been a provider for most of your career, you have a couple of attorney friends, or your general counsel has become a friend of yours because of how many deals you go through him, dating back to when you got out of med school. Do you find that sometimes the lawyers are the biggest hurdle to getting the deal done? Where they may just be fighting things, and the client may just be like, look, I need to get this done. And I can't tell you why I need to get this done, but this needs to happen on schedule.
Yeah.
Because
Yeah.
I'm maybe
Well,
IRS guy, or
yeah.
maybe they have a diagnosis on themselves that they're not wanting to tell anybody, or they need that next employment deal to start so they can give them 90 days notice that I don't give a shit, I'm out of here. You know what I mean? For whatever the reason. So do you find that happens a significant amount of time?
Yeah, a lot of times when clients say, hey, can you give me a quote for what this is going to cost? One of my first questions is who's on the other side? Because
Yeah.
that's going to really determine. And what I find is some of these law firms that are more sophisticated and do deals all the time, while they may be, they're not hard to negotiate with. I would much prefer to work with an experienced M&A attorney with healthcare experience and experience on healthcare deals than someone's litigation attorney or divorce attorney that's trying to help them out on the cheap. And the reason being is I'm going to sit here and argue with a litigator over a waiver of jury trial or a venue clause that probably neither of the parties really care about. When if I was talking to a healthcare M&A attorney, we can sit here and go, you do these deals, I do these deals. On the other side, I argue the same thing you are. Here's where my client is. Here's where your client is. What's market terms? There's deal studies out there. What is market? When I'm talking to a healthcare M&A attorney, we know what's market. We know when we're asking for stuff that's only going to get in 10% of deals.
Yep.
And we can just be candid and we can work through those issues. When you're trying to explain what this means to someone that doesn't understand healthcare laws, or why we can't, like, one of the biggest things is an earnout. I've had to explain to PE attorneys that aren't healthcare attorneys, but they're M&A attorneys, why you can't have an earnout and pay a physician based on how many Medicare patients stay post-close. Like, we can't do that. It's illegal. And so trying to get past that hurdle is a lot more difficult, and it frankly just racks up fees and frustration for everybody.
So if anybody's got any questions, by the way, throw them in the chat. Ray and I will definitely pick Sam's brain with this stuff, because for me, I find that a lot of this stuff that I'm asking her is stuff that I'm dealing with when we're helping set up these deals for our clients, or even for new providers that are wanting an opportunity to own the business, but the older partner didn't even tell them that it was an option. So then you're sitting here like, well, wait a minute. Hold on, let's stop everything. I'm not going to say I'm not going to pick up the private equity's calls, but if we have a deal here with a hometown guy that we brought into the practice and we didn't think he wanted it, but now all of a sudden he's saying, hey, if you're willing to sell to them, sell to me instead. It's a nice way to keep the legacy as intact as possible. And with some of these providers, it's almost like, I'll be honest, they have a better relationship with their practice than with their own kids. So they don't want the practice to just go to anybody. And and it just go to some soulless private equity that then is just going to flip the whole kit and caboodle in 6 to 18 months to an insurance company or to another private equity to then sell it all to a hospital because they're just multiplying the lives, right? Do you see that? Do you see that sometimes there's some providers that are like, hey, my junior just popped up out of nowhere saying, hey, I'll buy it. I'll buy this thing. And it's cleaner.
Yeah, a lot of times I will say, especially with smaller practices, before you do this deal, is there anybody internally that may want to buy? Before we enter into a letter of intent, and again, once you sign it, probably has an exclusivity provision. Now you can't go talk to anybody else. It may be something to discuss. Now that's always a sticky wicket there, because I may not want my employees to know that I'm planning on selling, because people freak out and leave, and I don't want, mass attrition when I'm ready to sell. But if there's certain key people that are partners already or ready to step up, definitely talk to your employees. A physician to physician sale is usually the quickest and easiest way to get this done. And then to your point, say just culture, right? What are your goals again? Because if I have a physician who's not ready to retire, but they want to sell because they're sick of running admin, well, guess what? You're used to hiring and firing and picking supplies and picking your vendors. If PE is going to buy your practice, their goal is to cut costs, increase the margins, and flip this again. Are you okay giving up control? One of the biggest things I find myself counseling my clients on is, are you really okay when you've built this practice from the ground up and you've owned it for 30, 40 years, turning over control to somebody else that you're now going to work for, and you don't get to call those shots anymore? And my biggest frustration with PE is they always come in and tell the physicians, you're going to stay in control. You're not. I'm here to tell you, you're not. They can't get their job done and make their money if you were still in control. They have their management services organizations. They have their preferred vendors. They're going to load this thing down with debt. They need to make cuts. They need to increase the margins. They will always tell the physicians, well, you're still going to own 51%. Well, great, because guess what? They're taking away all your voting rights, most likely. So you get 51%, and then they're going to have a management agreement, and they're going to suck all the profits out of your practice, so you get 51% of nothing. So on paper, it looks like you're in control. You really aren't. And that's the biggest thing I find myself on the sell side trying to counsel my physicians on is, yes, they have this clinical governance committee they set up for you, but guess what? This provision in here says tomorrow they can eliminate it if you give them a hard time. And when y'all don't show up for the meetings and they need to change something, that's what's going to happen. And so it's really figuring out who the appropriate buyer is and then counseling the sellers on, are you really ready to give up control?
Oh, I'll always tell them, you're how old? Let's just throw a number at the sky, 55. Okay. You haven't been an employee for 25 years. Are you really ready to clock in, clock out? Admin, not your problem. Your job is to show up, see patients, make sure the paperwork is nice and buttoned up right so they can bill on time. There's no more of this 72-hour messing around with the records on your desk stacked up a pile high, or the virtual version of that if you're using an EHR. But usually it's they still have some paper charts just hanging around, right? So I mean, are they ready to be good employees? Or how quickly are you ready to just be like, screw it?
I'm assuming that they're going to be ramping up patient intake too. They're going to be seeing a lot more patients.
Oh yeah. You think you can have 3? I saw one. He says that he needs 3 MAs for him in the office with him to see patients as a primary care. And I'm like, what do you need 3 MAs for, bro? If I told him flat out, I was like, if I'm the private equity that wants to buy your practice, one, half your visits are going to be telemed. So there goes one MA right out the gate. A second MA is gone just because of the fact that you don't get to use 6 exam rooms. Stay on time, bro. Payroll's killing me. So you're down to one, and you share that one with another provider. So get your ish together. You gotta see these patients. You gotta crank this out. So it's a different way to practice medicine that I normally find that they're not ready for.
Correct.
But but there are pros. I don't want to dog on mergers and acquisitions and all that stuff. But there's pros to this, right? Like, one big pro for me is I'm always looking at, okay, well, how are you going to help me with my day-to-day operations? Are you going to handle my billing? You're going to take all that off my plate? Are you going to take my HR off my plate? Are you going to take care of all of my compliance? Are you going to take care of my IT? Like, what are we doing? What is your purpose in existence, right? Like, you just getting the profits, or are you doing something to help the organization?
Right. Well,
So-
and I think that goes to the culture again. It's who's your buyer, right? And I'm not saying all PE companies are bad. There are practices that cannot, and in most of my practices, cannot survive alone anymore. Insurance companies squeezing them, the rates are bad. They're either really great at practicing medicine or really great business people, but typically there's just not enough time in the day to be really good at both. And so, back office MSO options could be a potential, could be helpful. PE coming in and cash infusion and taking some of that off their plate if they're not, efficient at managing business, not having to deal with HR. A lot of times there's a lift in payer rates, right?
Yeah.
Like, they pick a platform acquisition that has really good contracts. And now if I'm, the second acquisition, I get the benefit of those contracts. They've done an asset deal. I'm now on their contracts, and maybe I'm doing the same thing and making more money. So there are definite benefits. I'm not here to say, private equity is bad, but my biggest challenges have been getting physicians to not just look at the dollar signs and the fact that they went to a cocktail party and their friends have just sold, or I'm talking everybody's buying, everybody's selling, everybody's like, what, they got all this money. Talk to them 6 months to a year from now. Are they happy? Do they like the culture? Would they have done it again? Is it enough? When the physicians, a lot of time, I'm getting $25 million. Yeah, but half of that's an earnout. So if 12 and a half is all you're getting today at closing, is that enough if you don't get $1 more? Like, is that enough? The rest is a gamble. A rollover is a gamble. So we look at all those things, but really, I really encourage my clients to, if you're going to be acquired by somebody, ask them for references of practices they've recently acquired and go talk to them.
Absolutely. And I see that once a private equity starts hitting or they buy a practice in a market, they tend to heavily market that area so they can pick up as many of the used to be competitors as quickly as possible. I saw it a lot with the cardiologists and with the why am I blanking? Orthos. The orthopedic surgeons. And I mean, it made sense because the PE is like, I'm seeing stupid high numbers because of all the surgeries you do. We can probably kick in for an ASC or buy a standalone ASC and just roll that in. And now all of your procedures, now it's not just the 4 cardiologists, but now it's the 4 cardiologists plus the 4 orthos. That surgery center is booked. It's solid now. So, I mean, it can be really, really interesting with how people can set it up profitably, but comfortably, it's what's that phrase? All pigs get fat, but it's the really big ones that get slaughtered.
Hogs get slaughtered.
Hogs get slaughtered. There we go. See, that's my Puerto Rican coming out, not translating that one properly. So interesting. So I did mention, and I did warn you, I was going to ask you about this with the whole now that Supreme Court comes in and says, hey, Chevron is no longer going to be law of the land, even though it was never really a law. How is that? How do you foresee that differentiating? And for those that don't know, can you also give like a quick overview of what the Chevron decision was.
Yeah, so I think the case you're talking about is the Loper Bright case at the U.S. Supreme Court.
Yeah.
What is it? It's Loper Bright Enterprises versus Raimondo, and that overruled your Chevron case, which typically the Supreme Court would give agency deference, is what they would call it. You know, if we weren't sure how a statute or regulation was to be interpreted, they would give agency deference was the standard. So in the wake of Loper Bright, what happened is that agencies that issue federal employment regulations, they're no longer able to rely on Chevron deference. Now, don't get too excited about this, right? People are like, okay, great. If the FDA says something, I don't have to listen anymore. Or the Department of Labor says this. If it's not in a statute or a rule, we don't have to follow it. They can't just make up stuff, right? I think we've all dealt with some of the government agencies where you're like, that's not how I interpret the rule. But now you're saying, you know, you're denying this application for a certain reason that you seem to have made up. What
ACA,
did not
HHS,
happen?
CMS.
All of them. I think what we need to realize is important here is that it didn't overrule any case that applied Chevron deference, right? So those cases are probably still standing. Courts can still apply what we call Skidmore deference, which essentially is, that's another case, and that is essentially you can still, if the agency has consistently interpreted or has commented. So, you know, when regulations get issued, they have the comment period and they do Q&A. If they've already given guidance in there, the courts can still look at that, right?
Okay.
It leaves that open to some extent. So what it does is it kind of gets rid of the impromptu, this is our deference, the agency opinion deference. But if they've consistently published guidance, which the FDA does a really good job of, I think.
The
and
DEA does a really good job of as well.
CMS commentary, if it's been consistent and out there, I think you're still going to get deference there. And then the third important thing is that it says the statutes can still expressly delegate interpretive authority to federal agencies. So I think what it does is opens up to Congress to say, hey, like if you're going to make a statute, then what we need to do is make sure if you want to give agency opinion deference, it needs to say that explicitly in the statute.
So and I'm, by the way, again, law school of Google. If I understand this property, my schoolhouse rock, right? After everything becomes a law, the way that it goes down is the law then has regulations that are attached to it, but those are created from the individual, for lack of a better term, cabinet departments. And then those are those operating situations that that are the interpretations that now would be subject to this kind of consideration, correct?
Yeah, your regulations are still in effect. So it's kind of your unwritten stuff. So the statutes often say, right, the Board of Medicine will do this, right? Here's our rule. You need a certain level of like, for instance, let's say APRNs, and I'm using this at a state level, right? APRNs can do this. So there's a statute that says, you know, they now have autonomous practice, or they can prescribe controlled substances, and the Board of Nursing will then set forth rules, you know, setting forth which meds you can prescribe and not prescribe. So they give the deference to the agency. So that's where we get our regulations from. There's comment periods. So again, like really interesting case, and it'll be interesting to see how it plays out. But I don't think we just say if it's not a statute, we ignore it. Rules are still going to be enforceable. Commentary is still going to be looked at. But what this does is it gives the courts more leeway to exercise their own interpretations and judgment without having to give deference. So if you're arguing a case against a government agency, the government agency has the upper hand when the court is going to give them deference. When the court is not, and they can kind of interpret this, right? They can look at what the language is in the statute or the rule or the opinions and see, is this something that I should have expected in dealing with this agency? Was this approved? Did this go through the proper legislative process? Or now is it ambiguous and the court's got to decide what it means? It gives the court deference to decide that a little bit more than just the agency. The agency deference, you were pretty much, it's an uphill battle if you're up against that agency. Does that make sense?
So now what you're saying, and from what I'm understanding, and my biggest thing was, wait, so common sense has a shot. I can sit here and say, hey, why would you let my provider, using the APRN example for Florida, right? Why do they have autonomy, but they cannot prescribe medications for the extended period of time? You know what I mean? Like, so where's that come up? You know, like it allows us to have that conversation. I would hope now.
Yeah, and I think what it does is in the case that we had, right, the decision was really EEOC exceeded its authority when it issued a rule that was outside the bounds of what the statute said it could do, right? So if the statute says the Board of Nursing is going to determine what meds you can prescribe that are controlled, you know, you can do some, but we're going to say which ones you can or can't prescribe, nurse practitioners. If
Yep.
the board then says, and we're also going to set a rule for what level of supervision you have to have, and it doesn't relate to the meds or the statutory authority, right? That's where this kind of comes down and says, okay, we're not giving agency deference. You can't just make up rules. They have to be tied. You have to have the statutory authority first. And the statutory authority, you know, and you also have to, you can still make rules, agencies, but they have to be within the boundaries of that statutory authority.
Can't just throw a dart at the board and
if
let's
it's
go with this.
clear, if the statute's vague, we're not going to give you deference if just because you made up a rule, right? Like we're going to have to actually see, was that within, did the statute allow you to do it? So you have to have the statute, which is your law, to make the rule. You can't just have agencies making rules that are applied, you know, to deprive people of, right? I don't say punish people, but it could be criminal, right? But like, essentially people are held accountable. I can lose my license. I might not get my FDA approval. I might, you know, it just depends on what agency I'm dealing with. I might violate a Department of Labor rule and get fines and penalties. Like there are significant consequences. And so I think it's just that kind of checks and balances of power, just making sure like legislators make the laws. We give the agency certain authority to make the rules, but the rules have restrictions.
Darn, so it's not going to be as exciting as I thought it would be then.
No, it's not overturning every time there was agency deference. It's not overturning all those cases. Definitely, though, I think levels the playing field a little bit when you're up against an agency, because now the court can kind of have a little bit more independent judgment versus having to, you know, give deference to what the agency says.
Interesting. Cool. So, I mean, well, that makes things not as much fun because I love the chaos this stuff brings, you know, and see how they adjust. I wonder if anybody's going to adjust any of their rules internally just because we are coming up to final rule time in about a month. The final rules start dropping. So I wonder if anybody's going to just preemptively adjust just to avoid nonsense.
I think what you're going to see is, I mean, they're probably going to do what they're going to do. They're going to see what gets challenged. If there's stuff where they've been pushing the bounds or the statute may not be clear, like, is this rule really authorized by statute? You know, I think you may see a push to go back and rewrite some of those statutes that become problematic to be more clear, right? I mean, this is the thing. If we do a good job writing the statutes to begin with and they're clear, we shouldn't need, you know, the rules should expound on that, but we shouldn't have a conflict.
You're assuming politicians understand the healthcare system they built. What are you talking about?
This is why lawyers have jobs. This is why we have jobs, right?
It's the job security right there.
Sam, I can't tell you how many times I see a politician open his mouth and I'm like, well, if we did it your way, this would all be illegal.
This would be in the trash.
Like, we can't do it that way. Do you even understand the things that you're saying? So I mean,
to that note, we should also pay attention to some of the bills that just got passed in private equity realm as we're talking about M&A.
Yeah.
Right. New bill got passed. We got to keep an eye on it. Don't know if it's going to go anywhere, but it's definitely something, you know, right now there's a lot of scrutiny on private equity. So as our clients are doing deals, the feds are definitely looking at this. The FTC is interested from an antitrust perspective. We now have legislation proposed, right, that potentially makes it a lot harder for private equity to own healthcare or acquire healthcare entities. So just something to keep an eye on. I don't know if it's going to have traction or move forward. It's going to come up with a lot of challenges, but seeing it and what regulators are concerned about definitely raises eyebrows and is something we need to keep an eye on.
Well, I mean, we've been seeing it, and we talked about it a little bit yesterday. The private equity model has just been the wild west for a little bit in healthcare. They just, all right, we're going to get $10 million together, buy a bunch of practices, get as much debt as possible to buy more practices, and hope that when we flip this thing, it's somebody else's problem and we don't get stuck holding the bag. It's flip it, flip it, flip it so an insurance company gets it, then they can make up their own accounting rules and we're out of here. It's everybody's made their money. Almost like a Ponzi scheme, for lack of a better term. Right? Like,
Yeah, and I think and it depends, right? We see, I mean, there are definitely private equity groups that are in it to improve healthcare and, give
yeah,
opportunities to physicians and make things better. But like you said, because anybody can put the funds together and do this, right?
yep,
I mean, I don't necessarily have to have experience running a healthcare practice, or I can do this for the first time. And, there are patient lives at issue. And I think it's not just private equity, it's whoever we're selling to. Should insurance companies be running medical practices? Are hospitals in a position to do it? Because there's kind of a conflict there between, pocketbooks and hospital rates. I mean, there's conflicts everywhere. So I think it's just something we have to look at with all purchasers. The government definitely needs to be concerned about what's best for patients. But, we also have to realize you can't let these insurance companies keep squeezing providers and then take away their potential solutions to that.
yep. And I will say this right now. If you haven't been paying attention to what Congress is talking about right now, and you're in a you're in not an inpatient setting, they're literally talking about a 2.9% reduction on the outpatient rates to give it straight to hospitals. We're already charging out the nose because they're a facility. So talk to your congressman, get on their case. It's that time of the cycle where everybody's opinion matters, and this is how your MLR, or your SGR rather, was avoided for 20 years until they made up a new acronym, right? You gotta stay involved. Make sure your lobbying group is actually doing the things they're saying they're doing for your money, and then make sure your local congressman and your federal congressman know, hey, this can affect me negatively quite a bit, because 3% doesn't sound like a lot, but then to turn around and give it to the hospitals drives me nuts.
Yep. And one of my
It,
favorite colleagues and lobbyists had
That's
a saying
wild.
for that. What was it? If you're not at the table, you're on the menu. Like when it is time for a lobbying and you need to pay attention, you need to get there, you need to have your voice
that
heard.
is
You're,
I
amazing.
like
yeah,
that.
not at the table, you're on the menu probably.
Wow. He needs to trademark that. That's a good one.
That
That's a good one. Well, shoot, we're running right about that time. So I appreciate you jumping on with us, Sam, today. Um, I love these conversations, honestly, because this is where I really, really get into the weeds. And this is my natural instinct is, how can I find the loophole? Where's the loophole? Where's the loophole? Where's the loophole? Not to say I like to be the most clever person in the room, but I like to be in with the game with everybody else that's clever, I want to know that
I, I,
I'm wearing sheep's clothing, not a sheep, So
I
I
think
like to try to catch the play.
one
Huh?
takeaway for me is it doesn't seem a simple process when selling a practice. There's many factors,
Nothing is simple.
yeah.
and
Why would you think it's
I
simple,
can only,
Ray?
well, I'm not saying it's good. I'm sure Sam has never had a situation where it was just 100% smooth the whole way.
It's like, right?
That's
Yeah,
probably a pipe dream right there. But
you're trying to
Knowing
sell a house.
Sam,
Remember how stressful it was when you bought your first house or you sold a
oh
house?
yeah,
You're
I
selling
bought one
something
last
that is,
year. It
yeah,
was
the
intense.
paperwork, the issues. Okay, this is way more complex, but I
Yeah.
would encourage people, feel free to reach out, talk to us, talk to EPICompliance, talk to your consultants about what you want to do and your ideas, the struggles you're having in the industry, talk to each other, because hearing different stories and what people are doing and batting these ideas around is how you're going to get the best result for, what works for you.
and honestly, knowing Sam, if it was starting to go too smoothly, she would start kicking around other rocks, because her
Yeah.
spidey sense would be like,
Should find something.
nah, there's some
And
Wait a
there's some
second. This
big
isn't right.
nonsense running
This
around
isn't
here,
right.
because nuts.
we have missed something.
That's too funny.
She's looking for that trap until she finds it, but then she's not paranoid because she found it, right? You're not paranoid if it's actually there. You're just careful. So, if everybody, I mean, I know I enjoyed it. I would love to have you back on, Sam, maybe, 6 to 8 weeks or so, depending on your schedule. And we can come up with something else that I know that with that time of year, there's probably quite a bit of stuff that we can go over and have some fun with for a little bit and make interesting for everybody. I know next week we're doing the
We're gonna have your dad
next week
on. We're
is
gonna talk about the Medicare Advantage changes.
yep.
I believe that's
And
what we got
then
planned. Yeah.
cool. And then the week after that, we're doing we're going over the updates for all our big breaches of the year, the Ascension, St. Vincent, the Change Healthcare, and then with a special appearance thanks to CloudStrike, you know. So we'll go over the updates on that one. So if you've got anything on those, Sam, I'd be more than happy to bring you on and you can say your piece about them as well, you know. But
Absolutely, be happy to. It's always fun. It's always fun to get in touch with you guys and bat some of these ideas around. So really appreciate you having me today.
yeah, so
Likewise.
as everybody can tell, we've got Sam's information on here. This is the best way to get a hold of her. And honestly, she's extremely quick to get a hold of. And for whatever reason, if you can't catch this screenshot right now with the email, the website, or the phone number, you can always still contact Ray and myself, and we can get a hold of Sam for you and coordinate anything that we need and that you would need. But I would highly recommend. Sam, you're licensed in Florida and Ohio still, or?
No, that's inactive now. So just Florida right now. But if if anybody needs anything, we do have attorneys that we work with that, cover every state pretty much in the United States. And we also, can do business deals just about anywhere. So
Yep.
we're Florida focused, but we do have a national reach and actually an international reach. So if anybody has any international deals, we do those.
Ooh. Ooh, international
That could be a good
huh?
topic.
Yeah.
Fancy. I mean, but that would be crazy talking about. I mean, just the tax implications of an
That sounds
international
stressful.
deal.
That sounds stressful.
That sounds awful to
International
me. Wait,
yes, different compliance,
International
different
deals.
whole set of different compliance issues, but
Oh yeah.
all the time. In the medical device world, that's very common. So
yeah. Yeah, with all the technology coming out all over over the place, Europe and Japan and Korea and South Korea. South Korea's doing some crazy stuff out there, but maybe we'll talk about that one of these times, Ray.
Could be a good one.
Some stuff from other
healthcare tech
countries.
stuff too.
Well, yeah,
That fall in
that's
line?
what I mean. Like maybe we
Yeah.
can maybe one of our topics, if people are interested, we'll talk about some things that is our wish list of either drugs or technologies that are outside of the US, but for whatever reason haven't been able to get in here. There's so many of
I
them,
think
guys.
that'd be an
you,
interesting one.
I mean, Sam's probably got a list of a few of her own that clients have brought to her and been like, "Yep, you can't do that because FDA." And to get through FDA is a giant pain in the butt. But Europe, but Asia, nope, don't care. FDA is a giant pain in the ass. So, cool. We'll do. Yeah. All right, Jennifer. We'll take a look at that. Let's let's put that in the
Let's talk about
on the
that. I
list.
think that'll be a good one to talk on.
Cool. Cool, guys. Well, Ray, you got anything else?
No, I got nothing else to add. Sam, again, appreciate your time and your expertise, and we'll certainly see you on another one.
that sounds
Perfect,
great,
guys.
guys. Thank you.
Awesome.
Thanks,
Jose.
Stay out of trouble, guys.
You as well. Thank you. Thanks everyone for participating today. We'll see you on the next one. Take care.